Constitution of India, Part 9B, the Cooperative Societies, Article 243 ZH to Article 243 ZT. Article 243 ZH. Definitions. In this part, unless the context otherwise requires, authorized person means a person referred to as such in Article 243 ZQ. Board means the board of directors or the governing body of a cooperative society, by whatever name called, to which the direction and control of the management of the affairs of a society is entrusted to. Cooperative society means a society registered or deemed to be registered under any law relating to cooperative societies for the time being in force in any state. Multi-state cooperative society means a society with objects not confined to one state and registered or deemed to be registered under any law for the time being in force relating to such cooperatives. Office bearer means a president, vice president, chairperson, vice chairperson, secretary or treasurer of a cooperative society and includes any other person to be elected by the board of any cooperative society. Registrar means the central registrar appointed by the central government in relation to the multi-state cooperative societies and the registrar for cooperative societies appointed by the state government under the law made by the legislature of a state in relation to cooperative societies. State Act means any law made by the legislature of a state. State level cooperative society means a cooperative society having its area of operation extending to the whole of a state and defined as such in any law made by the legislature of a state. Article 243 ZI. Incorporation of cooperative societies. Subject to the provisions of this part, the legislature of a state may by law make provisions with respect to the incorporation, regulation and winding up of cooperative societies based on the principles of voluntary formation, democratic member control, member economic participation and autonomous functioning. Article 243 ZJ. Number and term of members of board and its office bearers. The board shall consist of such number of directors as may be provided by the legislature of a state by law, provided that the maximum number of directors of a cooperative society shall not exceed 21. Provided further that the legislature of a state shall by law provide for the reservation of 1 seat for the scheduled caste or scheduled tribes and 2 seats for women on board of every cooperative society consisting of individuals as members and having members from such class of category of persons. The term of office of elected members of the board and its office bearers shall be 5 years from the date of election, and the term of office bearers shall be conterminous with the term of the board, provided that the board may fill a casual vacancy on the board by nomination out of the same class of members, in respect of which the casual vacancy has arisen, if the term of office of the board is less than half of its original term. The legislature of a state shall by law make provisions for cooperation of persons to be members of the board, having experience in the field of banking, management, finance or specialization in any other field relating to the objects and activities undertaken by the cooperative society as members of the board of such society. Provided that the number of such co-opted members shall not exceed 2 in addition to 21 directors specified in the first proviso to class 1. Provided further that such co-opted members shall not have the right to vote in any election of the cooperative society in their capacity as such member or to be eligible to be elected as office bearers of the board. Provided also that the functional directors of the cooperative society shall also be the members of the board and such members shall be excluded for the purpose of counting the total number of directors specified in the first proviso to clause 1. Article 243 ZK. Election of members of board. Notwithstanding anything contained in any law made by the legislature of a state, the election of a board shall be conducted before the expiry of the term of the board, so as to ensure that the newly elected members of the board assume office immediately on the expiry of the term of office of members of the outgoing board. The superintendent's direction and control of the preparation of electoral rolls for and the conduct of all elections to a cooperative society shall vest in such an authority or body as may be provided by the legislature of a state by law. Provided that the legislature of a state may by law provide for the procedure and guidelines for the conduct of such elections. Article 243 ZL. Supersession and suspension of board and interim management. Notwithstanding anything contained in any law for the time being in force, no board shall be superseded or kept under suspension for a period exceeding 6 months, provided that the board may be superseded or kept under suspension in a case of its persistent default or of negligence in the performance of its duties, or the board has committed any act prejudicial to the interest of the cooperative society and its members, or there is stalemate in the constitution or functions of the board, or the authority or body as provided by the legislature of a state by law under class 2 of article 243 ZK has failed to conduct elections in accordance with the provisions of the state act. Provided further that the board of any such cooperative society shall not be superseded or kept under suspension where there is no government shareholding or loan or financial assistance or any guarantee by the government. Provided also that in case of a cooperative society carrying on the business of banking, the provisions of the Banking Regulation Act 1949 shall also apply. Provided also that in case of a cooperative society other than a multi-state cooperative society carrying on the business of banking, the provisions of this clause shall have the effect as if the word 6 months, the words 1 year has been substituted. In case of supersession of a board, the administrator appointed to manage the affairs of such cooperative society shall arrange for conduct of elections within the period specified in clause 1 and hand over the management to the elected board. The legislature of a state may by law make provisions for the conditions of service of the administrator. Article 243 ZM. Audit of accounts of cooperative societies. The legislature of a state may by law make provisions with respect to the maintenance of accounts by the cooperative societies and auditing of such accounts at least once in each financial year. The legislature of a state shall by law lay down the minimum qualifications and experience of auditors and auditing firms that shall be eligible for auditing accounts of cooperative societies. Every cooperative society shall cause to be audited by an auditor or auditing firms referred to in clause 2 appointed by the general body of the cooperative society. Provided that such auditors or auditing firms shall be appointed from a panel approved by a state government or an authority authorized by the state government in this behalf. The accounts of every cooperative society shall be audited within 6 months of the close of financial year to which such accounts relate. The audit report of the accounts of an apex cooperative society, as may be defined by the State Act, shall be laid before the state legislature in the manner as may be provided by the state legislature by law. Article 243 ZN. Convening of general body meeting. The legislature of a state may by law make provisions that the annual general body meeting of every cooperative society shall be convened within a period of 6 months of close of the financial year to transact the business as may be provided in such law. Article 243 ZO. Right of a member to get information. The legislature of a state may by law provide for access to every member of a cooperative society to the books, information and accounts of the cooperative society kept in regular transaction of its business with such member. The legislature of a state may by law make provisions to ensure the participation of members in the management of the cooperative society, providing minimum requirement of attending meetings by the members and utilizing the minimum level of services as may be provided in such law. The legislature of a state may by law provide for cooperative education and training of its members. Article 243 ZB Returns. Every cooperative society shall file returns within 6 months of the close of every financial year to the authority designated by the state government, including the following matters, namely annual report of its activities, its audited statement of accounts, plan for surplus disposal of approved by the general body of the cooperative society, list of amendments to the bylaws of the cooperative society, if any, declaration regarding date of holding of its general body meeting and conduct of elections when due, and any other information required by the registrar in pursuance of any of the provisions of the State Act. Article 243 ZQ Offences and Penalties. The legislature of a state may by law make provisions for the offences relating to the cooperative societies and penalties for such offences. A law made by the legislature of a state under clause 1 shall include the commission of the following act or omissions as offences, namely, a cooperative society or an officer or member thereof wilfully makes a false return or furnishes false information, or any person wilfully not furnishes any information required from him by a person authorized in this behalf under provisions of the State Act. Any person wilfully or without any reasonable excuse disobeys any summons, requisition, or lawful written issue ordered under the provisions of the State Act. Any employer who, without sufficient cause, fails to pay to a cooperative society amount deducted by him from its employees within a period of 14 days from the date on which such deduction is made. Any officer or custodian who willfully fails to hand over custody of books, accounts, documents, records, cash, security, and other property belonging to a cooperative society of which he is an officer or custodian to an authorized person, and whoever before, during, or after the election of members of the board or office bearers adopt any corrupt practice. Article 243 ZR Application to multi-state cooperative societies. The provisions of this part shall apply to the multi-state cooperative societies, subject to the modification that any reference to legislature of a state, state act, or state government shall be entrusted as a reference to Parliament, Central Act, or the central government respectively. Article 243 ZS Application to Union Territories. The provisions of this part shall apply to the Union Territories and shall in their application to a Union Territory having no legislative assembly as if the references to the legislature of a state were a reference to the administrator thereof appointed under Article 239, and in relation to a Union Territory having a legislative assembly to that legislative assembly, provided that the President may, by notification in the official gazette, direct that the provisions of this part shall not apply to any Union Territory or part thereof, as he may specify in the notification. Article 243 ZT Continuance of existing laws. Notwithstanding anything in this part, any provision of any law relating to cooperative societies in force in a state immediately before the commencement of the Constitution, 97th Amendment Act 2011, which is inconsistent with the provisions of this part, shall continue to be in force until amended or repealed by a competent legislature or other competent authority, or until the expiration of 1 year from such amendments, whichever is less.